Now, at the same time, other amendment also, it's a different topic, but we have amended this Indian patent law after 2001. We have amended Indian patent law in after 2001. What is the specialty of 2001 in when we discussed WTO? It is Doha Ministerial Conference. What is the other name for Doha? Doha Development Agenda. Doha Development Agenda. Doha Development Agenda. Under the Doha Development Agenda, developing countries have won a very important right under TRIPS. What is that? TRIPS versus public health. TRIPS versus another very important issue in relation to TRIPS versus public health. What does it mean, TRIPS versus public health? This provision were added under the Doha Development Agenda or in the Doha Ministerial Conference. It says that if a country's public health system get affected due to certain reasons, mainly because of some emergency, mainly if a country is having an epidemic, in that case, that member country can violate TRIPS agreement. This is what is called as TRIPS versus. So if there is a fight between public health and TRIPS, public health prevail over TRIPS. This was agreed in the Doha Ministerial Conference. That's why this Doha Development Agenda is very important. Now as part of this, now I'll tell you, as part of this under the TRIPS versus public health, a new provision in the, we have a provision what is called as compulsory license. This is very, very important under IPR, compulsory license. You know, regarding license or licensing we already discussed. What is licensing? A patent or a intellectual property holder giving my right to use this right to someone else. I am telling you use it, my right. You use it and give me royalty, give me fee for it. So normally licensing is given by the patent or any intellectual property holder at his discretion. Whenever he feels so, at his own terms and condition, he give licensing. Now what is this compulsory licensing? You know compulsion. Compulsion means it is not the holder will, it is somebody is compelling. Who will be compelling here? It will be compelled by the government. The government will compel a patent holder. Government will compel a patent holder to give license to a third party of its own invention, and then this third party can sell that product and give the patent holder a very minor fee which is decided by the. For example, if the drug which I am having is priced 1000 rupees, I am making profit, means 1000 rupees means I am making profit of 950 for each drug. I have patent, that's why that's 1000 rupees. Now suddenly an epidemic happened. Now everybody want this drug. So because of my, I am a patent holder, what I am trying to do, that either I will not increase, I may, because there is more demand, or I may reduce it for 900 or 800, the government will realize that this price is not affordable for the common man. If the government feels that there are certain cases in which the compulsory licensing provision can be used. One of the provision is that this drug is not affordable to the common man, to the people. Means the price is very high. In that scenario, the government will ask another pharmaceutical company to produce the same item and sell at a very lesser price. This is what is called as compulsory license. Now regarding compulsory license, this compulsory license provisions we have added because of this TRIPS versus public health provision. Now whenever this public health issue happens, the government can compel a patent holder to give that rights, licensing rights to someone else, and he will produce that drug and sell it at a very affordable prices. Now be very clear, this is concept is all about. What do you mean by compulsory licensing? Now again US is against this compulsory licensing. US is against this compulsory license because it is taking away the right of a patent holder, a patent especially mainly a pharmaceutical company. Now try to, there are certain rules to be followed while issuing it. At any circumstances the government can't do it. There are certain criteria. The TRIPS agreement says that there are certain criteria at which if this criteria is fulfilled, then only a compulsory license can be issued. And one of that criteria, if you take the material page, which write it very important there, page number, see in which page it is showing, page number 16. In that there are 3 points have been given in page number 16, right? Important, and in page number 17 you had seen section 3D of the patent law, write it, that also very important. In that compulsory licensing there are 3 points. One is the reasonable requirement of the public. One condition is that the reasonable requirement of the public means the common man with respect to patented invention, if it is not met, if the reasonable requirements of the public, if it is not met by the patented invention, then the government can issue it. This is what is TRIPS says that. Second is regarding the price. The price has to be affordable to the public. That is the second provision. The patent invention is not available to the public at the reasonable price. Not available means it is not affordable. So in that case they can issue it. Then the patent have not worked in that particular territory. The patent invention is not working in a particular territory. So, but the first 2 provisions are very important. Third provision normally is not used. But again I am telling you, in case of India, only once the government have issued compulsory license. That too in the case of it was given to Natco company, Natco Pharma, which is an Indian multinational company, to a drug Nexavar. So it's very important, factual. Nexavar, an anti-cancer drug. Nexavar is an anti-cancer drug of a company, Glivec. Sorry, not Glivec. Bayer. No, sorry. The Bayer is the multinational company. Bayer. Its Bayer drug, anti-cancer drug is Nexavar. Now the compulsory license is given to, so the government have asked an Indian company, Natco Pharma, to produce this drug. What? This drug actually it belongs to Bayer. By issuing compulsory license, what it has done? Natco Pharma will produce this drug and sell it at a reasonable price. So in only once we have issued compulsory license, but again this, when the government have taken this step, it was again created a big hue and cry was created by the multinational company. Again regarding, try to understand that this issue of compulsory licensing is another controversy or another issue in relation to intellectual property rights. Now be very clear, if there is any mains question, and if they are asking about issues in relation to intellectual property rights, both section 3D and compulsory license have to be there in your answer. If it is related with India's law, Indian patent law, or in issues in relation to, because these are the 2 issues in which US have put India under priority watch list. It's not in relation to copyright, it's not in relation to trademark, it's not in relation to GI, it's only in relation to patent, India's patent law, especially section 3D and compulsory license provision, which India have used it. And they fear that India may use this compulsory licensing provision in future also. Compulsory licensing provisions in future also. So be very clear with both these concepts. It has to be there in your answer. Now this is the two issue, compulsory license and section 3D is very important issue. Now while dealing with patent, few more things you need to be very clear in relation to patent. First of all, be clear that the right, these rights, especially in relation to patent, they are territorial rights. Patent rights are territorial rights. Be very clear what do you mean by territorial rights. Now when we say that it is territorial rights, for example, an inventor, Indian territory. When you say that patent is a territorial right, I am an inventor from US. If I want to use this right in India, what I need to do is I have to apply for patent in Indian Patent Office. I might have got patent in US, but if you want to get patent in India, you have to apply to Indian Patent Office, and the Indian Patent Office, once they give patent only, they can use that right in Indian territory. That's why it is called as. Now if they want to use it in Europe, again they have to apply to Europe. If they want to use in Sri Lanka, they have to apply in Sri Lanka, and the Sri Lankan Patent Office will provide it. So be very clear, patent are territorial rights. Don't say that if I got a right in US, I will get the same right in India. It can be rejected by the Indian Patent Office. Now in relation to patent, one important thing you need to be very clear is that when a patent holder apply for a patent in India, what the Patent Office does is, it will ask whether is there any pre-grant opposition. Pre-grant opposition means the Patent Office is going to grant patent to this a patent holder. Do you have any opposition? That's pre-grant opposition. And if somebody have opposition, they will take their claim, Patent Office will look into it, and if it is found reasonable, it will not give patent. If it is not reasonable, it will give patent. That's pre-grant opposition. Then even there is post-grant opposition also. After granting patent also, if somebody knows that okay, this is my own patent, he can go and oppose it. So pre-grant and post-grant opposition is there. Once this both pre-grant and post-grant opposition is settled, that patent holder can enjoy the patent granted for next 20 years from the date of where it is approved. Now very interesting point about patent is that as part of the exclusive right to use the patent, the patent holder have to disclose the patented invention or the technical information to the Patent Office. You have to disclose the information. Patent holder have to disclose the patented information. But to whom initially? To the Patent Office. But later on, after certain period of time, this Patent Office will put in the public domain. See, the technical information will be available in the public domain to anyone. But it can't be used by anyone for this 20 years. After that, anybody can use it. That's the specialty of patent. So in this 20 year, you can, so the basic aim, the social purpose behind is that let people knows about it and let people use the technology and make improvement and make life better for the people. So that's the purpose about, so be very clear about this, how patent is applied and for what purpose this right has been given. In return, he have to disclose the information, the technical information related with patent. So be very clear. Now regarding compulsory licenses, there is one more condition, is that the any government can issue compulsory license only after 3 years. See, I have applied for a patent. After 3 years only, the compulsory license. So in the initial 3 years, you are safe. But after 3 years, if this any condition is applied, compulsory license can be issued by the government. Just there the material, but just have an idea. See, actually, then if within the 3 years, if there is any epidemic, then it can violate. But normally, without, see the three conditions. Three conditions never talk about a epidemic or public health issue. Three conditions says that one is reasonable requirements of the public, second is affordability, and third is it is not working in India. If it is not working only, you can use it after 3 years. But TRIPS versus public health is a different case. Epidemic happens, no other thing the government can, no nothing to be followed. This is actually, see, the compulsory license provision, which is what the TRIPS says, is what I had said. But this can also be violated if there is an epidemic. The government, see, there nobody can say anything. It is basically the interest of the nation will come first. Be very clear with that. Okay, so this is just have an idea what patent is all about. I told you again, among all the intellectual property rights, patent is very important because from the income arising from patent is very huge. And try to understand that why there is why the people or the government have been given or the industry has been given patent is that we need more patents or we need more inventions for a technological society or a techno-economic society like the present world which we are living. We require more inventions. More inventions will make our life happy and better. You are seeing that now. Today a new technology is coming, tomorrow a better technology is coming. Now this technology will not come in a day. The technology or invention will happen because of the time, money spent by the creator or the company. For he might have spent years for creating that product or that process. So in order to promote many people to come and do research and develop something, this exclusive economic right have been given. So that's again, it's to promote invention or innovation only. This exclusive economic right under intellectual property right has been given. So that you don't say that IPR is not good. IPR is good, but misuse of IPR is not good. So that stand you need to be taken.